This is case number 17-101-335. This is Lincoln Financial Recovery Group versus Cherie Coles. The matter is before the court on an application for a subpoena, and the court did grant that application setting today's date as the date for hearing. Your appearance for Lincoln Financial on the Zoom. Counsel for Lincoln Financial, do I have on the Zoom Cherie Coles? Right. It appears now that the plaintiff, neither party has shown up here on this particular subpoena. The court is going to dismiss the subpoena where the plaintiff has not. That dismissal will be under advisement pending the conclusion of today's hearing. If counsel comes in, the court will revisit that matter. All right, the court now calls case number 21-240431. This is Maui Howard versus Michigan Auto Recovery. The matter is before the court, set on for a pretrial hearing. The record should reflect the court did allow for the period of discovery and set today's date as a subsequent pretrial hearing date. Your appearance at this time, do I have Maui Howard or anyone representing that person, please? Your appearance at this time. All right, look like I see Mr. Stedham there. Your appearance, sir.
Good morning, Your Honor. Thomas Stidham, P56504, on behalf of the defendant, Michigan Auto Recovery Service Incorporated. Also with me, Judge, is Gregory Arrigo, the president of the company. He's on the iPad. He's muted right now.
All right. Thank you, counsel. Good morning to you. Good morning to the two of you. Again, I am looking for a plaintiff or anyone representing the plaintiff in this matter. It's Maui Howard. Please say something if you hear the record.
Yes, sir. I'm Maui Howard here.
All right, thank you, Mr. Howard. Good morning to you, sir.
Good morning, sir.
All right, so I did set this on for pretrial, also allowed for filing of motions. Counsel, let me address this to you. Have you been able to get discovery in this matter? Update me on the status of this at this time.
No, Your Honor. We anticipate filing a motion for summary disposition on this with respect to this matter. We're asking the court just to give us a set of schedules so that we can do that.
All right, so I did give you a schedule the last time that you were here. That allowed for the filing of the motion as well as discovery. Let me go back to my original question with regard to this matter. Did you, counsel, did you seek any items of discovery regarding this case during that time?
I did not, Your Honor, because when we went back and looked at the complaint, we realized that the initial thing that we had anticipated seeking discovery on, does not appear that we needed it.
Gotcha, counsel. That's what I needed to know. All right, Mr. Howard, I did open discovery the last time that you were here to allow you to discover any information that you might have needed from Michigan Auto Recovery. Did you seek any discovery, request any items from the defendant in this matter during that time?
I requested nothing from him, sir.
All right, very well. So what they're asking now, it is set for pretrial. Counsel has asked the court set a date so that the parties may be heard on a motion that they intend to file in this matter. A motion is a written document requesting that the court does something. It is required that you be notified whatever that document is, that you be given an opportunity to respond to that written document or written motion that will be filed by Mr. Stidham. So I'm going to set a date for a hearing on that matter, although the motion is not filed yet. When it is filed, Mr. Stidham will be required to make sure that you get a copy of that, and you will want to respond to that in writing, if at all possible, and as quickly as you can once you have received the motion. So I'm going to set this matter over, and I'm going to set it out just beyond 30 days, and I'm going to require that any motion in this matter be filed within the first 20 days of that period of time. The balance of that time will be opportunity for Mr. Howard to respond to the motion. So the motion hearing date is going to be
April 4th. Yeah,
keep that in March.
yeah, you want the 30th?
March 30th.
Mhm.
March 30th is going to be that date, Wednesday, March 30th.
Yeah. Before we get on the record,
Madam Recorder, is that you? So again, March 30, 10 o'clock a.m. is going to be the motion hearing date. And so council will file his motion in this matter not later than the 17th of March, not later than the 17th of March. And any response that you would like to file once you receive that document, Mr. Howard, you'll need to file it. You'll need to file it before the hearing date. So you'll have some 10 days to file it. So try and get that in by the 28th. By the 20, not later than the 28th. You should do it sometime in the 21st, not later than the 28th of March if you're going to file a written response to the motion that's going to be filed. And again, I will hear the motion on 3/30 at 10 o'clock a.m. All right. I wish the two of you well. Any questions at this time?
Yes, sir. Well, okay, what motion are they filing? Because I really couldn't understand what.
Yeah, it sounds like to me, council indicated that they wish to file a motion for summary disposition. This is a stage in the proceedings where either side can file a motion, a document asking that the court would consider certain matters. A motion for summary disposition is where the plaintiff is, strike that, in this case, it would be the defendant indicating by a written document that they do not believe that the complaint as submitted to the court is sufficient to sustain your case. And of course, you have a chance to respond to that written motion. And the court will read the written documents, and I will hear argument on the motion on the 30th, and we'll make a decision.
Okay, so is there any way I can get an attorney?
Yeah, I
'Cause
cannot point you one because it's a
Yes,
civil case. You can certainly hire a lawyer. We only appoint lawyers in criminal type cases. Can't do that in civil cases, so you'd have to get somebody involved.
See, because like I understand what you're saying, but I don't really know how to file motions and all. You know, I'm not an attorney. See, I never expected for it to have to go like this far, and they're it's been going on for almost 2 years.
Right.
You know what I'm saying? And
Yeah,
I'm not understanding all these motions and stuff, Judge. I'm sorry for overspeaking you, but
and that's understandable that you would not understand those matters because you're not a lawyer. But when you file something with the court, you're held to that same standard. So you have to become aware of the things that you have to do. Now, a motion again is simply a written document petitioning and asking the court to do something. Doesn't mean that the court will do it. It means that you or the other side can ask the court to do something, and you have to present some factual basis and or some legal reason why you believe the court should take the action that you think the court should do. And then the court reviews that. And this is a stage at which that is done. That's done typically before trial. And if the motion is granted, that means that the case would be dismissed. If the motion is denied, then it means that the case will go forward and the court will likely set it for trial unless the parties are able to reach a way to settle or resolve it. So that's kind of where the case is now. If you wish to hire a lawyer, you want to act on that quickly. As you said, the case has been going on for some time, not in front of this court, but you've indicated to me that it's been more than 2 years. Of course, this case was filed in this court. Looks like sometime in February of 2022. So it's been a year. It's been a year pending before this court. I'm taking a close look at that to make sure that I've got that right. Just one moment here. Well, actually, it looks like it's been pending before this court since sometime in June of 2021. So about 6 or 7 months, or going on 8 months, whatever it may
Yeah,
be.
I started off in the regular small claims court, and then they start. So I know you can't give me any legal advice, but is it a way I can amend the cost for this to add to? Because I have to pay for an attorney over my stuff being stolen out of my vehicle.
Yeah,
You know,
you
I
can,
was wondering.
you can certainly raise that. You can certainly raise that issue when you, if you hire a lawyer, you can certainly raise that. You can certainly raise that issue once your case is presented to the court. And of
Okay,
course,
thank you.
if there is, as is always the case, if there is something that makes no sense about the approach that will be taken by either side in here, that's an issue that we're in the court can award attorney fees and sanctions and other type of calls. So those issues are always on the table. If you're going to hire someone, you need to let that lawyer know that you have a hearing on this matter on the 30th of March at 10 o'clock p.m. so that lawyer can know to react to those dates. Also give him the paperwork that you would have received from the court and also from Mr. Stebbins so that he can reach out to him and they can move forward in making sure that no time is being wasted. You understand?
Yes, sir. Thank you.
All right, I wish you well. Good day to all.
Thank you, Judge. Have a good day.
All right, the court now calls case number 21-157-419. This is Farmers Insurance Exchange versus last name is Lippett, Deja Aaron Lippett. The matter is before the court set for a status conference. Your appearance for Farmers Insurance Exchange, please.
Morgan Stage on behalf of farmers.
All right, your P number, if you will, Madam.
Oh, yep. It's P83793.
All right, thank you, Counsel. Good morning to you.
Morning.
I'm looking now for Deja Lippett or someone representing defendant Lippett. Please indicate your appearance at this time. All right, so I do see where there was an answer filed in this matter. I also see where the court sent out a notice regarding today's hearing date, and that notice went to the address provided by Khadijah Lippett on John C. Lodge Street in the city of Detroit, setting the time at 9:45. Again, I'm looking for Khadijah Lippett, living on Lodge Street in the city of Detroit. If you're on the Zoom, please say something at this time. That reflect upon the notice that was sent out. It does have the correct Zoom number. Madam Counsel, have you had any contact with the defendant in this matter?
No, we have not, Your Honor. And also, not sure what's in your file, but we appeared for a status conference back in October on this matter. And the defendant also failed to appear at that time. At that time, you mentioned that we should submit an order for default judgment, and we did that. The register of action shows that that default is entered. We just don't have a copy of that, so we're not quite sure where we're at on the matter. And then also, if we need to file a motion for that default, well, we're happy to do so. We just thought it had been handled at the last status conference or after the last status conference.
All right, thank you, Counsel. The record should reflect that the court did in fact enter the default of the defendant regarding this matter. But the court was awaiting the hearing on today's date to determine whether or not the default judgment would enter. So the default has already been entered.
Okay.
That default was entered when the defendant did not appear at the last hearing. The defendant has again not appeared at this hearing. The court having previously entered the default of the defendant, the court now will sign the order allowing for the entry of the default judgment. The judgment will now enter in the amount of $12,003.55 as prayed. And I'm signing that order. We'll get that out to you.
Thank you, Your Honor.
right, this is case number 21-172-820. This is HS Financial Group versus Anisha Jones, living at 11, living on West Parkway Street in the city of Detroit. Today is the time set for a hearing on the application for entry of default judgment. The defendant has previously been entered in this matter of the application entry of the judgment. Your appearance for the plaintiff in this matter, please.
Daniel Weberman, P76609, on behalf of the plaintiff.
All right, thank you, Mr. Weberman. Let me see if I have Ms. Jones on this Zoom. Anyone representing Tamisha Jones, living on West Parkway Street in the city of Redford? All right, it appears, and I have a couple of indications that that address is in Redford, and another place that's in Detroit. Given that the default has previously been entered and defendant received mail indicating the Zoom address and has not appeared regarding this matter, the court will enter the judgment now by default on terms as prayed. The default will enter, the judgment will enter $2,532.16. I'm signing an order consistent therewith at this time.
I thank you, Your Honor. I don't need to submit anything further, do I?
That's correct, sir. Thank you.
All right, thank you, Your Honor. Have a good day.
All right, this is case number, 1 second. All right, this is case number 21-240-690. This is Gail Reed versus Protective Window and Door. The matter is before the court, set on for review at this time. The last hearing, the defendant in this matter requested opportunity to go over some photographs, and parties were engaged in looking for a way to see if this might be included short of further proceedings. All right, do I have Gail Reed on this Zoom? Gail Reed? All right, I see that I have counsel for Protective Window and Door. Counsel, your appearance at this time, sir.
Good morning, Your Honor. Michael Norman, P75844 on behalf of Protector Window and Door.
All right, thank you. Thank you, Mr. Norman. I do see that I'm calling this a little bit early, set for I was looking at the previous date, 9:45, so set for 10:30. Have you spoken? Did you guys get to talk about this a little bit?
We did talk. I don't think we reached a resolution, but I would be happy to hang out until after 10:30. Your Honor.
Gotcha. That's I'll get back to it shortly after that time, sir. Thank you, Mr.
Thank you.
Okay.
Yeah.
Okay. Oh,
Do you want me to sign that? Sign.
You have to decide this here.
Yeah.
Yeah, I think. Yeah, you good. I just make a copy.
Thank you. All right, the court calls case number 21-157-588. This is LBNB Funding LLC versus Tamara Reed. The matter is before the court, set on for a hearing on an application for entry of default judgment. The default of the defendant has already been entered in this matter. The defendant did not answer, otherwise plead in the underlying matter. Your appearance at this time for the plaintiff's plaintiff.
Yes, good morning, Your Honor. Joseph Jamal on behalf of the plaintiff, P71254.
Thank you, counsel. The court is looking for Tamara Reed, a person living on Washburn Street in the city of Detroit. If you are on this Zoom, please say something at this time. Reed. it appears that the defendant has not appeared for this hearing, although it's been duly noticed. The court now will enter the default judgment, finding that it is due to the plaintiff the sum of $1,686.33. The judgment will enter as prayed. I'm signing that order at this time.
And you do have a copy of that proposed judgment on your file, Judge?
Yes, sir. I've signed it, and we'll be getting a copy out to you, sir.
Thank you.
All right, thank you. The court now calls the case 21-156-814. This is LBNB Funding LLC versus Sinkia Powell. The matter is before the court on an application for entry of judgment by default. The record should reflect that the default of the defendant has been previously entered. A hearing was set on this matter for entry of the default judgment. The defendant was in fact notified, given the proper Zoom address, to appear on today's date. Do I have Sankia Powell on the Zoom? All right, and Mr. Jamal, you represent the plaintiff LBN Funding on this matter as well. Is that correct, sir?
That's correct, Judge. Joseph Jamal on behalf of the plaintiff, P71254.
It does appear now that the defendant has not appeared for this hearing. The defendant did not appear regarding the case itself, did not file an answer. The court accordingly will enter the judgment by default now on the terms as prayed, finding that there is due to the plaintiff the sum of $1,042.46. Judgment will enter for that amount at this time. The court is signing the order that has been presented.
Thank you, Judge.
Thank you, counsel. The court now calls. Case number 21-161409. This is Jefferson Capital Systems versus Deborah Johnson. Matter is before the court on the application for entry of default judgment. The court also calls 21-162647. This is Jefferson Capital Systems LLC versus Geneva Watson. The matter is before the court on the filing of an application for entry of judgment by default. The record should reflect that in these matters respectively, defendants did not file answers or otherwise defend in these matters. The default has been previously entered. There is a request now for entry of default judgment. I'm looking now for Geneva Watson. Geneva Watson, if you are on the Zoom, please say something at this time. Geneva Watson, a person living on Tuxedo Street in the city of Detroit. The court now is looking for Deborah Johnson. Deborah Johnson, a person living on East Ricksdale in the city of Detroit. Deborah Johnson, if you're on the Zoom, please say something at this time. Matters were set on respectively for 10 o'clock a.m. regarding the suffix 409 and 10:15 a.m. regarding the suffix 647. All right, counsel for Jefferson Capital Systems LLC, your appearance at this time, please.
Morning, Your Honor. Brian Truba appearing on behalf of plaintiff Jefferson Capital Systems. My P number is P61752, and I'm appearing for the plaintiff on both cases.
All right, thank you, counsel. And I reviewed these matters, sir. It looks like the respective defendants did not appear, although notified to appear on today's date. Accordingly, the court will now sign and enter the judgment by default with regard to the suffix 409, Deborah Johnson. Judgment will enter for $794.82. Court will likewise enter judgment in the suffix 647 regarding Geneva Watson for the total sum of $5,497.59. I'm signing orders consistent with those amounts at this time. And counsel, you receive copies in the mail. Thank you, sir. Good day.
Thanks, Your Honor. Have a good morning.
All right, this is Gail Reed versus Protector Window and Door regarding case number 21-240690. The matter has been before the court set on for review on today's date. The parties discussed the possibility that this might get resolved at the previous hearing, and the court set it over for review at this time. Your appearance at this time, counsel. Sorry, let me have Gail Reed, if you're on the Zoom, say something at this time.
Gail Reed is on the Zoom at this time.
All right, good morning to you, Ms. Reed.
Good morning.
And counsel for Protector Window and Door, your appearance, sir.
Michael Norman, P75844, on behalf of Protector Window and Door.
All right, thank you, Mr. Norman. Good morning to you as well, sir. So I know that you talked about this matter, and by your being here, it seems like there's probably some indication that you've not been able to resolve it at this time. Is that true?
That's correct. Yeah, we I've not reached a resolution. We did, I guess, contact her about some repairs, but it wasn't acceptable. So I don't know if we need to just put this on a set it for a trial date or mediation.
All right, got you. All right.
Your Honor, if I may respond to Mr. Norman?
No, don't respond to him.
Or not to him, but respond to what was shared by Mr. Norman.
Well, you didn't reach an agreement. That's the part that's obvious. And then you got to go to the next step because you can't reach an agreement in this matter. So tell me what you want to tell.
Well, we didn't reach an agreement. I was contacted on February, but they've only tried to rectify one part of the lawsuit, which is the latter part, not the major part of the lawsuit. So we didn't reach an agreement because they didn't address the entire lawsuit issue, just a part of it. So I just wanted to make sure it was the burden, because, you know, with terminology, it was almost as if the burden was put on me as to why. Again, that's just my interpretation. So I just wanted to clear up why we did not reach an agreement.
Wow. I still don't know why you didn't reach an agreement, but I'll tell you this much. I know that you didn't reach an agreement. That's the issue. That's
yes, sir.
I don't think that blame is direct to anybody. You just didn't reach an agreement. Within the course of the human condition, people sometimes don't reach agreement. I guess that's why there's a little bit of sustainability with my job. Sometimes it just don't reach agreement. Sometimes that's for good reasons, sometimes for bad reasons, sometimes just because people don't agree all the time. All right, so that leaves the case wide open. There are a couple of ways to do that, to do this, and one of them is to set up some type of alternative resolution and send it to some type of mediation to allow them to take a look at both sides of what parties have to say and see if they can assist you in reaching some resolution. I see that the total amount of the claim that is brought before the court is in the nature of $1,000 plus court costs. So let me ask you, Mr. Norman, it sounds like some of this had to do with something about remediation. Was there something on the table about correcting something? Is that what some of the discussion was? I can't get into all of that. But is that some of the discussion?
Yeah, some of the discussion was just repairing some work.
All right. So, Miss Reed, did you have any objection to there being an effort to remediate or to repair some condition that may have existed?
No, I'm not against it, but they have to address the issue at hand. If they address the issue at hand, yes.
I didn't ask you that, did I? And there are critical reasons why I didn't ask you that part.
Yes, sir.
My question was real basic. So let me ask the next question, and this goes to both of you. If there is not a disagreement regarding the need to remediate, again, for purposes of trying to resolve the matter, then can you agree to remediation of this matter in terms of correcting whatever problem there may be? And then leave the other question open for a subsequent determination. Does that make sense to you, Mr. Norman, Ms. Reed? Does that make sense?
Yes and no, Your Honor. Part of the dispute, and I don't want to get, start telling the court about all the facts. Part of the dispute is that it doesn't make sense what my client is willing to remediate based on what Ms. Reed wants wouldn't make sense to do what we're willing to do and then have to come back and potentially do what she wants us to do.
All right, so let me go a little bit further that
Wonder what's supposed to be done.
I'm sorry?
Nothing. I'm not saying anything.
The remediation would be designed to correct whatever the outstanding condition is. That's about what will occur. Is that correct, Mr. Norman?
Yes.
Ms. Reed, do you believe that the remediation or the correction of the condition that has been set forth, that would correct the physical condition that has brought this matter to the court?
Can you repeat that? I'm not quite about to understand what you're asking.
What I'm asking you is that there's been an offer that sounds like it involves remediating or correcting a condition secondary to some work that Protector did at your home. Would their plan to correct that, would it in fact correct the underlying issue?
No. What they proposed, when I spoke to Mr. Norman back on the 9th, no, it was not going to rectify the issue.
Would not repair it would not repair the window or the door?
Right, they only addressed, again, just the casing, not replacing the slab that was damaged prior to arrival.
Okay.
Prior to installation, prior to arrival, that issue has not been addressed, only the casing, and which I share with Mr. Norman.
Let me stop for a moment. There's only so much you can get into because I may have to try the case and hear the details. That's why.
Okay, yes, sir. Thank you.
So if the installed part as well as the casing is corrected, this would not be a case where there is a request for monetary damages. Is that correct?
Correct.
So Mr.
If the issue.
All right. So Mr. Norman, if the condition is going to be remediated, if the plaintiff here says that if the condition is corrected in total, that there is no longer a case for damages. Where is the breakdown in this narrow way as you can tell me?
There is a difference in opinion as to what needs to be remediated and what's related to the install versus what's not.
Has anybody given you, without telling me any numbers, has anybody given you an estimate as it relates to what Windows is willing to do and what Ms. Reed wants them to do? In other words, the difference between what Windows is willing to do and what Ms. Reed wants them to do, the cost differential, and what the actual cost differential might be for that additional piece of work as your client proceed.
It's about $1,000 difference between what she would like my client to do versus what they have offered to do.
Well, that's that I can see why you haven't been able to resolve the case. All right. So I'll go ahead and set it up for a trial date. I could send it to mediation. I also have an agency that I can send it to for attempts at dispute resolution. But you're pretty far apart on that in terms of what the parties perceive should have been done. Let me just take a look at one thing, just 1 second.
I'm sorry.
So in the complaint, it says that a replacement entry door, back door was to be installed. But the door was damaged when it arrived. And then the complaint stops there. I was told a replacement door, let's see if there's something. I was told a replacement door would be ordered and installed. But it doesn't say that there wasn't a replacement door ordered and installed. Was there? Is that what happened? It wasn't ordered and installed?
Are you asking me, Judge?
Yeah, I'm reading your complaint, and it seems like your
Okay.
complaint, that's something I said, the company protected window and door came to install a new entry door, or back door. Upon prior to arrival, the door was damaged. It was told a replacement door would be ordered. And it's
Yes,
there.
and on October 14th of 20, it was shared with me that the slab was ordered. Oh, I'm answering your question.
No, I need a real clear answer.
Okay, so I was told it was ordered, however, it was not installed.
Okay, so you didn't put that in there, but what you're saying is that the door that came was damaged, and then they told you they were gonna get another door, and then they never got the other door. Is that what you're saying?
It was, I don't know if they received it or not. I know I did receive it, but yes, sir, that's correct. It was not, I have not received the replacement door, and the casing has not been installed. That's correct.
So, protector windows, they brought a door out, correct?
Yes, and well,
That door was, and you're saying that that door they brought to replace was damaged, correct?
correct.
So, Mr. Norman, so is there a disagreement regarding whether or not there's a door that should be replaced?
Yes, that's the major disagreement. There was a door installed at Ms. Reed's home.
All right, very well. So let's, what do you want me to do, guys? You want me to send you to some type of mediation to work this out? Or you want me to just go ahead and set it on for trial?
I would be happy to go to mediation if Ms. Reed would be, but I guess I will leave it up to her as to whether she wants to mediate before trial.
I'm okay with mediation. And then if we don't reach an agreement in mediation, will it then be set for trial?
Yeah. Yes, ma'am.
Okay.
All right, so let me get it set up for some kind of mediation. You'll get an order from me for mediation of this matter. And then I'm gonna set a date for you to come back and see me. Hopefully it gets worked out. If it doesn't, again, you can come back to me and we'll try to figure a way to conclusion. Let me ask one other question. Ms. Reed, have you reached out to any other entity in an effort to get the condition corrected with regard to your back?
No, that would be additional funds. No, sir, I have not.
You love to answer my question with some stuff other than the answer, don't you?
And I know yes, and I apologize. I'll stick to the question. No, I have not.
That's okay, ma'am. I'm kind of picking with you a little bit now. All right. All right, good enough. course, I'm thinking about a lot of things, so I'm trying to get you to the finish line on both sides of this, okay? So I will sign an order for mediation regarding this matter. You get an order from me in the next few days. And we're gonna set this over, gonna set it out about 45 days because that's the soonest that I can get it back, because you got the mediation and the interim. So the date that I'm gonna give you now is going to be my clerk is looking, just one second.
April 4th. What about April 18th? April 11th. April 11th.
4/11/22 at 9:45 a.m. 4/11/22 at 9:45 a.m. That's when you'll be coming back to see me. You'll get an order in the mail from me for mediation of this matter. Present your side and summation, and then those persons make a decision as to what they think should happen regarding this case. It's kind of interesting and intriguing. All of us probably here are homeowners, and when there's something at your home, you kind of want to get at it and get to it as quick as you can. When there's a disagreement regarding stuff, sometimes that can tie things up. And time is money, et cetera, et cetera, et cetera. And so that's why I'm glad I didn't have another case pending on here right now. So I was able to take a moment to at least try to talk about it, just to try to figure out a way to try to close this out, especially on this, they call it Tuesday today, TWO day, because we got all these twos. Of course, 2 is the number of agreement. And I was hopeful that perhaps with all these twos, 2, 22, 22, that we could find a way to do some kind of resolve. But I'll get the paperwork out to you just to some type of resolution. All right, I wish both sides well. And good day to you.
Your Honor, I have a question, please.
Yes, ma'am.
The mediation, is that being handled between me and the defendant, or is that something you're also going to send out, a mediation request or information?
I'll assist in getting that set up. Yeah,
Okay.
That's why I'm going to issue a court order to make sure that gets set up.
And that'll be via mail. You'll send something via mail with the mediation information.
Yes, ma'am.
And if I may, a second question. Is 36th District still closed? That second floor?
We've never been closed except for a brief period of time. But you mean people walking in and all that?
Right.
Let me ask somebody.
No, she coming.
Yeah, you can come
They
in.
come in. Mhm.
Yes, you can come in.
Okay.
I know that there are things you can do online, but you can actually come into the building to the second.
Okay, and is there anything I need to present to the court during this time of waiting on the mediation and this second trial, this April 11th date to see where the parties are?
No, don't have to submit anything to me.
Okay.
You present that to a mediator, someone that will take a fresh look at it.
Okay,
right.
thank you.
You will. You'll get the date and you'll get the notice of the date as well as the mediation stuff in the mail in the next few days. All the best to both.
Thank you, all the best.